Good morning, and what a glorious morning it's turning out to be for Indian citizens. The Supreme Court, in a unanimous decision, has said that the right to privacy is a fundamental right of every citizen of India. Paiswani is here to break that down to you into a little bit more detail based on the detail coming in. But also with us is Rajeev Chandrasekhar, a man who has been fighting hard for this in his own way, a member of parliament as well, and a well-known, industrialist. But first, Paiswani, a quick few details from you on what we know so far.
We just have essentially 3 lines from the Supreme Court, which is going on to say that the right to privacy is a fundamental right, which is they have said it's part of Part 3 of the Constitution, which deals with the fundamental right, and they have also read it into Article 21, which deals with life and liberty. So in both the areas, and I think we'll talk to lawyers in a bit to try and understand why making it part of both these articles is important. So the bench has essentially said that the smaller benches so far that had ruled the right to privacy as a fundamental right were correct in their ruling, and both MP Sharma and Khadak Singh have been overruled by this 9-judge bench, and it's a unanimous judgment.
Yeah, just for viewers, MP Sharma and Khadak Singh are references to 2 cases from India's past in which the Supreme Court, in smaller benches than 9-judge benches, had ruled that right to privacy is not a fundamental right. They were very specific to those 2 particular instances, and the judgments then too were nuanced. But today's judgment, I think, clears the air for once and for all.
Absolutely.
And how critical it is to explain that. Rajeev Chandrasekhar. Rajeev, good morning. Congratulations.
Morning.
I know you played a vital part in this battle. Congratulations to all of us as well. What do you make of this announcement?
Yes. No, I think, look, Veneka, this is something that you are aware that a number of us have been arguing for many years, and this is probably the 4th or the 5th year that we've been in this battle to make sure that while we do digitize our economy and we have all of these things that are happening around us, that the fundamental right of a consumer and a citizen to safeguarding his information, his data, his privacy is never compromised. And I've always maintained privacy is a fundamental right. There were people in the political system, in the media and elsewhere that did not believe that was true. And this had to be adjudicated at the Supreme Court. And I'm glad that all 9 judges have ruled that this is a fundamental right.
Rajeev, you want to tell us the importance and the significance of this right to privacy being now part of both Article 21 and Part 3 of the Constitution?
No, I think it is very significant because it basically, if you see that where this originated in 2013 when people felt that Aadhaar was really a platform that was being developed with no fetters and no protection for the people who were going to be enrolled into Aadhaar. And if you remember that there were a large number of, there was quite a concerted attempt to argue that there was no need for rights of citizens and etc. But having this in Article 21 and in schedule will basically imply 2 things, that this is a fundamental right, but it will also be subject to reasonable restrictions. It's not an absolute right. So it is not the privacy as purists would want it, where the state has no ability to ask for data information or, in a sense, intrude into people's lives at all. The state will have the right, but the right of the state will come with very strong reciprocal obligations on the part of the state or any other entity that essentially deals with people's information, people's data, and people's lives. So this is really an important milestone in the way we are creating an architecture of rights for consumers and citizens as the nation moves into a different type of democracy where technology and digitization and onlining of people's lives and information are only going to increase.
Rajeev, I do want to talk to you a little bit more about the Aadhaar connection, but we'd also like to include in this conversation Siddharth Luthra, senior counsel at the Supreme Court, who's also often represented the government in the past as a government lawyer. Siddharth, good morning to you. The criticality of the way in which the Supreme Court has found this to be a fundamental right, could you share your legal view on what this means and how this will get interpreted?
Firstly, I must say that since the days of MP Sharma's judgment, we have come a very long way. And there has been a greater expansion of the scope of all the fundamental rights by the Supreme Court. I think this needed to be said. The Supreme Court has rightly stated that the right to privacy is part of the Article 21 rights, and it was a very important milestone that there needed to be clarity across the board. According to me, while the earlier judgments took a certain view, it was a contextual view in a time and place when there was the understanding of privacy as we know it today did not exist. And therefore, while those judgments were very well in that point of time, the way change has come about in our reading of the Constitution, privacy ought to have been and has rightly been recognized by the Supreme Court as a fundamental right and part of the gamut of fundamental rights that every citizen has. Now, while that has been done, what is interesting is that what is to be seen is how this is going to be applied, and we've not had the full text of the judgment yet, but how that's going to be applied in the context of Aadhaar and in the context of a score of areas. Because today we are, with the mobile phone in our pocket, we are liable to surveillance even by the telecom companies who can actually, by way of their locational, they are aware of our movements. So there has to be a relook at how technology is going to apply to citizens and how government is going to regulate to ensure that the citizens' rights are protected. And that, I believe, is the way forward. Will government regulate? Will government leave it to self-regulation? These are areas of law that are going to be considered in a variety of places. And secondly, there is also concern that the regulation must not be such as to deprive the right of privacy. So there are these two contexts that are going to arise, and this judgment is going to make way not only in this area of law, but also I think there is going to be a recognition of a larger body of rights as time goes by, because this is going to be a milestone achievement in the Supreme Court's history.
Okay, Mr. Luthra Payaswini here from the Bloomberg Quint studio. Mr. Rajeev Chandrasekhar pointed out that the significance of putting this right to privacy both under Article 21 and Part 3 is that it will come with reasonable restriction. What reasonable restriction do you anticipate will come in? And second, I cannot not ask, what does it now mean for Aadhaar?
Well, I'm sorry, on the second part on Aadhaar, I'm really not in a position because I've not had occasion to read the entire judgment. But reasonable restrictions, therefore, is, as I would see it, to that extent the view taken by the Attorney General to say that while right of privacy is recognized, it is a right subject to restrictions, which means the reasonable restrictions are in Article 19. Are on Article 19 of the Constitution. And those reasonable restrictions are laid out in 19.2. And if those are going to be read, then as long as the government frames laws or schemes in the context and within the parameters of those restrictions, that law will be valid. Now that's what we'll have to, as I said once again, read the full text of the judgment. It's premature to get into this debate so soon.
Okay, Mr. Luthra, do you also anticipate that this judgment will impact some of the other pending cases, for instance, NAS Foundation, for instance, the WhatsApp privacy case, where I understand you were also closely involved, though, like you said, we don't have the benefit of the full text of the judgment, but do you anticipate that this ruling will now impact the various other pending cases where this right to privacy is being argued?
As a policy, I don't comment on cases I've appeared in or am appearing in. And since I've appeared in NAS and I'm appearing in WhatsApp, I would not like to comment on that at all.
Do we have Mr. Rajeev Chandrasekhar with us? Mr. Chandrasekhar, would you want to take this question since Mr. Luthra is conflicted here?
No, I think, look, we have to go through the text of the judgment. That is for sure, to understand what further the Supreme Court has said to clarify, qualify, explain the issue of privacy as a fundamental right. I think we have to wait. There is no doubt in my mind that there will be a need for all of the legislation, including the Aadhaar Act that has been passed, to meet this test of privacy being a fundamental right. We've spent a few years being blown away by the spin that Aadhaar is designed for privacy and people need not worry about privacy and it's nobody's business to talk about privacy and all of that. All of that gets junked. I think this is a new era where a certain proposition has been framed and now confirmed by the Supreme Court that privacy is a fundamental right. And the state and every other player in our ecosystem, digital or conventional legacy holders of data, must conform to this expectation and that consumers and citizens have a right to privacy vis-a-vis their data, information, and whatsoever. So I think this is a brand new world. This is almost a reset of the last 4 years of toing and froing that we've had. And I think this is a good way to start a new conversation about all of these things that we have been wanting to do in our nation, of bringing platforms and technology to help eradicate corruption, help direct benefits and subsidies for better, but doing so keeping in mind that there is a reciprocal obligation to the citizen to maintain his or her privacy.
Rajeev, just to make the limited point that this does not at any point in time mean that we still don't need to work on a data protection law, because those two go hand in hand. The right to privacy is the bedrock of any data protection law. That too needs to be an ongoing effort to protect everything that you've just mentioned in the previous answer.
Absolutely, Menika. I think what this does is establish the baseline in terms of what the rights are. Every legislation past or in the future will have to meet the test of this being conformed to. It is no longer about a group of bureaucrats deciding what data protection and privacy is or not. This will have to be the basic tenet around which legislations past and present will have to align themselves to.
Yeah, Siddharth, if I can ask you, and I know it's early as yet and we don't want to speculate on what the text of the judgments are, if there are multiple or if there's one, but can you explain to us what it means to have reasonable rights on the right to privacy? Where does, our right to privacy begin or end, and where does the state's right to intervene begin?
Now, the restrictions that are read into Article 19, and if you just, if you see 19.2, makes it very clear that the restrictions are things such as public order, security of the state, then friendly relations with foreign states. So these are some of the broad parameters in 19.2, and if these are the parameters on which a legislation can be brought to contain that right. There is nothing else that a legislation can do beyond the restrictions in 19.2, and those are the restrictions that will have to be read in when we look at the right to privacy.
And those are the restrictions that in fact also affect many of our other freedoms, such as the freedom of speech, which is not an absolute one in this country. Have I understood that correctly?
Absolutely. You see, the Article 19 contains the freedom of speech, the freedom to assemble, the freedom to have associations, the freedom to move, the freedom to live in any part of India, the freedom to work, have a profession. All of these are restrictions. All of these have restrictions which are contained in Articles 19, sub-article 2 to 6 of Article 19. Now, those restrictions are the ones that will have to be seen. And I would assume, and this is purely an assumption because, as I said, we've not seen the judgment, I would assume that this will really fall within the scope of perhaps, 19(1)(a), which is freedom of speech, the freedom, Article 19C, the freedom to form association, D, perhaps to move freely, and G, to practice any profession. Now, these are the areas which would be part of your privacy rights. And if these are part of your privacy rights, then the restrictions which are read into these rights will then also will be read into the privacy right that has now been carved out.
Siddharth, we have a couple of more questions for you to explain to our audiences what the nuances of this are. But before that, Arpan Chaturvedi, Bloomberg Queen's reporter at the Supreme Court, is waiting outside to give us a sense of today's very historic and landmark decision. Arpan, what a day in court it's turned out to be. Take us through all the basic information that you've been able to glean from that morning in court.
Absolutely, Menika. So as we have been discussing that it's very premature to discuss in detail as to what will be the right and what's the definition in the detailed part of the judgment. But I think the most important part has been that it is a unanimous decision by 9-0. That's what the lawyers are telling us, because at 10:35, the Chief Justice came and just read main parts of the order. And I think two highlights in that. One, the Chief Justice said that right to privacy is intrinsically a part of Article 21, which is one of the most important important fundamental rights, the right to life. So that's what the Chief Justice said, that the bench has decided to place it in Article 21 as well as other parts of Part 3 of the Constitution, which has the other fundamental rights as well. That was one. Then the other judgment was that it's a 9-0 decision, and most importantly, you have to remember the importance of this case. It's very rare that we see a 9-0 or 9-judge bench sitting on a subject. I think in the last 10 years, it was only previously in the entry tax case that we saw a 9-judge bench, and in privacy they have ruled 9-0. That's the main outcome of it. The Chief Justice read that the bench has also decided to overrule the previous two cases, which were MP Sharma and the Khadak Singh cases. Both these cases now stand overruled to the extent that they held that there is no fundamental right to privacy. The Chief Justice also read that the other subsequent cases which have held that the right to privacy, there is a fundamental right to privacy, that is the correct reading of the law, and that lays down the law correctly. For more other details, I think we will have to wait for the detailed judgment to come out. But two important parts: right to privacy is intrinsically a part of right to life and liberty, and that it's a 9-0 unanimous judgment as far as we have understood.
Thanks very much for that. You're going to hang on. I'm sure you've got a bunch of reactions to gather right outside the Supreme Court. So we'll keep coming back to you as you have more on this. Paiswini, I know you have a couple of questions for Siddharth, but I have just one very small technical question to him. And that is that, Siddharth, I know it's tough without the full text of the judgment to sort of try and gaze into what might happen to cases such as the Aadhaar one. But I'm just curious to know, will they now have to be argued afresh right from the start, because the opening position itself has changed, and that is that, you know, privacy is a fundamental right with whatever restrictions it comes with?
I think I want to answer that a little differently. Let me explain one with you historically. You see, it's not that privacy was not recognized earlier. If you look back and you look at even the Khadak Singh case, there's a dissent, and that dissent of Justice Subbarao excuse me, that dissent of Justice Subbarao was the basic dissent which indicated that there is a right to privacy, as I recall. And that dissent has now become really essentially the law, but we'll have to see the new judgment. Now, so far as the other cases are concerned which are pending, this judgment is obviously going to have some impact. The extent of the impact has to be seen, because the issue really will be the scope of this judgment, and have they skirted away from the other pending issues in the court, or have they also opined on other legal issues which are pending and which are under consideration before the court?
Siddharth, thank you very much for joining us this morning.
Menka, Apar Gupta is also joining us. He's been tweeting and writing on this issue very passionately. Apar,
a warrior in that team
space,
of people. Yes.
And Apar, euphoric day for you this morning?
Yes, it was an important day also because I represent clients before this court. It's an issue I don't only believe in personally, but I'm also a part of this professional representation. So it's a huge victory for all of us, because privacy as a right is much broader than Aadhaar. It applies to various facets of our life and is basically a guarantee for our individual freedoms, all of us.
Okay, Apar, do you want to help us understand, to the limited extent that we have the information, what can you glean as from this as the implications for some of the pending cases in the courts today?
So the first clear implication, which is indisputable, is that the cases will proceed ahead. The cases were not proceeding because of the pending reference on the question of the existence of the right to privacy, which was decided today by the judgment. And this reference has been pending for about 2 years, because which a lot of cases which concern the question of the existence of privacy as a legal and constitutional right have been stayed till the decision came. So there will be movement. There will be decisions which will be coming, and that's the first clear implication. The second clear implication is that privacy is now a right. So in all these cases which will now then move ahead, they will need to consider privacy as a right under the Constitution. The two tests of this judgment, as the panelist was stating earlier, will be on the basis of the reasoning given by the judges and its subsequent application to real-world examples. 9 judges today answered a query whether our Constitution protects us and grants us the right to privacy. But the actual protection will flow through the true test of legislation and violations to privacy, which will now be determined by the court on the basis of this judgment.
Apar, many more questions to put to you, but we're also joined now by Supreme Court Advocate Karuna Nandi. Karuna, not only is this a landmark decision, but it's been taken in a landmark way, 9-0 in favor of the right to privacy. What would you say about that?
It's a good day, Menika. It's a really important day, actually, because, had we not had the right to privacy, imagine how everyone would have felt today, right? 9 judges have unanimously held that there is a fundamental constitutional right to privacy located in Article 21. And I think that, MP Sharma and Khalak Singh were red herrings, but, they have swept those considerations aside and they have decided that Indians do indeed have such a right.
Okay, Karuna, can you also take us through what do you make in terms of the implications of this for some of the pending cases?
With the Aadhaar case, the councils were arguing with one hand tied behind their back, essentially, without being able to sort of proceed on the fact that there is a right to privacy, right?
Right.
So that's something that will go ahead. Now, the Naz judgment is up to be cured before a 5-judge bench, the 377 judgment. Of course, at the curative stage, you can't really... let's see if they consider this judgment, because of course we have U.S. cases that held consensual, activity to be within the home, or to be constitutional on the basis of the right to privacy, right? To go to the U.S. where the Fourth Amendment was also expanded on the basis then of subsequent judgments. There were, of course we have abortion here, but there was Roe versus Wade, which held that a woman has a right to privacy of her body. There in the context of abortion, here we don't have that problem. But, there's a way in which bodily integrity also potentially could be argued on the right to privacy. The marital rape case is coming up on Monday. I am one of the people arguing it. And we are arguing that the exception to marital rape should be struck down. And we will now be arguing, that a woman has a right to bodily integrity. And that, to some extent, is predicated on privacy.
Yeah.
Because they have located that right in Article 21, you see.
Okay. Arpan Chaturvedi, my colleague in Delhi, also caught up with Sajan Puvaya, who was one of the lawyers who had argued in favor of right to privacy. Let's listen in and what he had to say.
The Supreme Court has finally declared that there's a fundamental right to privacy. What is your first reaction and what does the judgment say according to you clearly?
I think, it's a very proud moment for every citizen in the country. The citizenry has won. The Honorable Supreme Court has, delivered its verdict, which is groundbreaking. It has indicated that privacy is a fundamental right. Privacy is a fundamental right residing not just in Article 21 but other parts of Part 3 of the Constitution, and has declared that the previous judgments which indicated that privacy is not a fundamental right, that is 8 judges, all those judgments are wrong law and they have been overruled.
And so this reference on privacy came in the case of Aadhaar. So
yes.
Going forward, what do you see the impact of this on other cases?
You see, the whole issue before the 9-judge Constitution bench was whether privacy is a fundamental right, and that has been upheld. Now that privacy is a fundamental right, on the touchstone of privacy being a fundamental right, Aadhaar has to be tested. That will be a different issue altogether. It will go back to the bench which was hearing Aadhaar, and arguments will be on it. But the fact is this, it is not that Aadhaar is good or bad per se.
Yes.
The issue is that now that privacy is a fundamental right and that declaration in unequivocal terms has come, you have to now test the Aadhaar architecture vis-a-vis the fundamental
And
rights.
the final clarification, it's a unanimous 9-0 decision, right?
As far as what we have seen based on the pronouncements, none of us have had the opportunity of reading the judgment. We find that it is a unanimous, although separate judgments. I think about 6 judgments have been authored, but the opinion of the court is unanimous that privacy is indeed a fundamental right.
All right, sir. Thank you so much for joining us on Bloomberg Quint.
All right.
Long reading day ahead for us based on that, Menika. 6 judgments that have come in.
Well, not surprising at all, given that it's such an important matter. What I do want to take back to both Apar and Karuna is this question to try and explain to our viewers what kind of impact this could potentially have on the Aadhaar program, especially because, I think this has become so intertwined with our daily lives. It isn't just about the direct benefit program. It is also now a part of our income tax filings. It might soon become absolutely mandatory for stock market transactions. So I think it's critical to try and understand what the concerns were regarding the Aadhaar program that now might be fixed by today's judgment if this were to be taken in whatever detail and to whatever extent into the Aadhaar hearings as well. Apar, if you're there, could you explain this to us? All right, it's one of those days when all our guests are scurrying around, Apar and, being part of the case,
right.
Having a bunch of other things to do, and everybody wanting to try and understand and get comments from that. But I think this will be probably the one most critical application of it, though we cannot underscore how important this right is, not just from the Aadhaar point of view, but every single other right, every single other freedom point of view.
Of course, and also in the list of the things that you mentioned that Aadhaar might become mandatory for the financial transactions already, for banks, etc., Aadhaar is becoming mandatory. So, there also the implications will be in terms of what that right to privacy means.
All right, we have more comments coming in from right outside the Supreme Court. Well-known counsel Prashant Bhushan commenting on today's landmark decision. Let's listen into what he has to say.
Right now, it appears that all that this 9-judge bench has held is that this is a fundamental right under Article 21, and therefore any law which is made to restrict this fundamental right will have to be examined on the touchstone of Article 21, which means that the court will have to see whether that law imposes reasonable restrictions on your fundamental right to privacy or not. That privacy is a fundamental right is all right, but any fundamental right is subject to reasonable restrictions imposed by law. Whether the Aadhaar Act imposes reasonable restrictions or not will have to be examined by a separate bench.
All right, that was Prashant Bhushan commenting on this. We've got you a welter of voices since this decision first was put out this morning. That is Rajeev Chandrasekhar, Karuna Nandi, Apar Gupta, Sajan Puvaya, and now Prashant Bhushan, all of them lauding the fact that in India we finally have a Supreme Court bench in unanimity declaring that the right to privacy is part of our fundamental right.
Arithmetically, we couldn't have asked for anything better, I think.
Yes, I'm sure there will be more nuance to be read into the various judgments, 6 of them, as I think was, told to us this morning. There are 6 judgments in totality, but the unanimity is 0-9. That's where we are on the right to privacy. A couple of more important things that we can wrap up on in terms of what this morning's judgment has brought us till we get the fine print.
Sure. So let me just recap for the people who joined us a little late. So the Supreme Court has said that we have a right to privacy under Article 21 of the Constitution and Part 3. Rajeev Chandrasekhar explained to us that by the significance of this is that we do have the right to privacy, but with reasonable restriction. That's the significance of reading that into Article 21. Several of the panelists also told us that it will have an impact on some of the pending cases, whether it is the NAS Foundation case, whether it's the WhatsApp privacy case. There were arguments also by the government as if you declare right to privacy as a fundamental right, it will have an impact on the Right to Information Act that lays down the privacy angle. So we have to explore that angle as well once we get the full text of the judgment. For that, come back to Bloomberg Quint this evening at 7:30, where we will examine the fine print of the judgment. Yeah, one last point to make before we wrap this up altogether, and Paiswani, that is that this is the last 2 working days for the current Chief Justice of India, Justice Kehar, and I know he's faced, he's faced quite a bit of criticism in his brief tenure as Chief Justice, but he's going to go out on a big high because I think this is the one judgment that many people will remember the Supreme Court under him for many decades to come. So I think we'll end on that. Thanks very much. And like Paiswani said, make sure you stay tuned to BloombergQuint.com and come back at 7:30 to join us with a more detailed analysis of what the Supreme Court has said today. Thanks for watching.